Mhm.
Anybody here on behalf of Benjamin Levine or Rebecca Smith? Let's see. Two. Is that what this is? That's what this is. On the record in the matter of Hamilton Road LTD versus Claude Miller and all occupants. This is file number 23-01344 LTE, council appearance.
Good afternoon, Your Honor. Darwin Fair on behalf of the defendants Claude L. Miller and the occupants.
Today was the date and the time that was set for a motion hearing. I don't know where Mr. Turnwell is. Let's see. Mr. Turnwell has failed to appear. There was a response that was submitted. Did you receive that response?
Your Honor, if you're making reference to an affidavit that was filed yesterday, that's the only thing that I'm aware of. But having said that, we checked the registered of action and saw that the affidavit had been filed yesterday. We have not received a copy of that affidavit. We emailed Mr. Turnwell about that affidavit and asked him to email it to us to no avail. Last time we were in court, I promised Mr. Turnwell that I would call him to see if we could resolve this matter. I called him and I did not get a a response. So I don't know what Mr. Turnwald is doing in this matter, Judge.
Okay,
But we're
you
ready to
filed
proceed.
a
I'm
looks
sorry.
like you filed a motion to dismiss in lieu of an answer. Is that correct?
I'm sorry, Judge. Is that a question to me? Did I file a motion?
Yeah, did you file a motion to dismiss in lieu of an answer?
Well, actually, we filed an answer and we filed a motion to dismiss.
Okay, it looks like on July 3rd, we did receive a response to the motion to dismiss for lack of jurisdiction from Mr. Turnwald's office. So you're saying you did not receive that?
I did not receive that, Your Honor.
Okay, and then yesterday, today's the 11th. Yeah, yesterday we did receive an affidavit. I believe that was to accompany maybe this response to the motion. They failed to appear, and so I'll let you proceed at this time with your request.
Hey, Your Honor, if I may, though, you've stated that they filed an answer, and I have before me the registry of action, and I just don't see that. But
yeah, I have a date stamped here in the file for July 3rd at 1:27. Response to motion to dismiss for lack of jurisdiction.
Okay.
That's what we have here.
Okay, I don't see that on the register of action, but that's fine. Having said that, Judge, we did file a motion to dismiss this case for lack of jurisdiction pursuant to 2.116. And that court rule is pretty clear that says the motion may be based on one or more of the following grounds and must specify the grounds on which it's based. Another action has been initiated between the same parties involving the same claim. And so there is a circuit court case that we attached to the motion for summary disposition that was filed. And they both, these both cases address the same issue, which is ownership of the subject property and whether the plaintiff in this matter has the right as owner to evict the defendants. And that specific issue is currently before the circuit court. And so this court rule was promulgated in order for them not to have inconsistent results. So and the fact that we're talking about the circuit court, we should allow the circuit court to make a determination with regards to the quiet title action that was filed in this matter. We have stated the case law that that supports this position, and there in fact is a circuit court case that raises again the same issue, and it would constitute irreparable harm if the defendants in this matter were evicted from their home and then they prevail in circuit court litigation. As you know, if they prevail, they would be out of their home, which is just unfair and irreparable harm when it comes to real estate. We also argued in the alternative, and quite frankly, Judge, I don't see why we should do this. Is a motion for stay pending the outcome of the circuit court case. But I can understand for administrative reasons why the court may want to do that. But if the court does, our position would be that we should not have to pay escrow in the interim, particularly since the other side hasn't showed up. So based upon these oral arguments, Judge, and the fact that the plaintiff has not shown up, I'd ask that the case be dismissed. And again, Judge, I'm troubled that I did not get a copy of their motion. And also, Judge, my office always checks the register of actions. And again, I do not see, and maybe I'm reading it wrong, because I could be reading it wrong, but I don't see where they filed a response. But having said that, we did not get a copy of it. And I did email him, Judge, today for a copy of the affidavit that I knew about, and no response.
Okay, I will see if we can figure out why it is that you don't see this response, at least from July 3rd. and on the register of action. Do you see that in GIS? It's noted here in our system, in the judicial information system, so I'm not sure why you don't see that. As to your request for relief, I'm going to grant it for the reasons that you stated in your argument, but also for the fact that the counsel for the plaintiff has failed to appear. I clearly and distinctively remember Mr. Turnwall being present at the first court date, or at least our last court date, and both parties, you and he, speaking and stating that you would speak off the record to try to resolve this matter. So it was a bit troubling to hear that you reached out to him and you've not been able to make that contact to do that. But I believe that the basis for your relief is sufficiently pled here in your brief and motion. I will grant your request to dismiss this case for lack of jurisdiction. Could you provide an order?
Yes, Your Honor, I'll provide an order. And I understand I can email that to the court.
Yes, you can send it to Judge Simmons Courtroom at lansingmi.gov.
Okay, I will do that forthwith, Judge.
Very good. Any additional matters for the record today?
I have nothing further, Your Honor.
Okay, you're all set. Thank you, sir.
All right, thanks, Your Honor.
What's this?
So we'll just set that up and we can just run some file that before we came upstairs.
Yeah. Yeah, there's this slightly more. Okay, on the record in the matter of Davenport University versus Sam Dixon, file number 21-00660. Where's Sam Dixon?
Good afternoon, Your Honor. John Hintz appearing for Davenport University. Mr. Dixon appeared and answered all of my questions. So I was just coming back into the courtroom just to let you know that everything was good. And I might have taken a liberty, Your Honor, but since he answered all of my questions, I was content and I said he was free to go. So
No problem. That's fine with me.
just wanted to let
you,
you know, Your Honor. Thank you, Your Honor. Have a good day.
Same to you. On the record in the matter of Coding Sowers versus Nicole Garvey, file number 22-03632 SP. Have your appearance, please.
I appear on my own, Nicole Garvey.
Oh, Codeine Sowers.
Thank you. Today is the day you're appearing without counsel, correct, ma'am?
Yes, ma'am.
Today is the date and the time that was set. It says for a discovery proceeding. Did the parties meet already? For the discovery matter?
No,
No, ma'am.
Okay, why not?
I just learned of this court date. And I did not have
Well,
time. to
You
prepare.
filed, you wanted a discovery hearing? A debtor's exam? Okay, well, then they need to meet. I don't conduct those hearings for them. We do also have a motion for installment payment order here in the file, it looks like. Let's see. Okay. Did you receive a copy of the motion for installment payment order?
I did not. Possibly it was sent email, but I did not realize he sent that.
Okay, well, the defendant is requesting to make payments in installments. You're requesting to pay $25 a month. Ms. Garvey?
Yes, ma'am.
Okay, you owe $15,000. You recognize that?
Yes, ma'am.
Do you know how long it will take you to pay $15,000 off at the rate of $25 a month?
Yes, ma'am.
And you believe that that's reasonable?
At the moment, yes, I am the only current person working and trying to maintain my household. My rent just doubled.
Okay, you have another court order which you're paying $4,806 a month.
Yes.
What is that? That judgment before this court? Can you look up 21-00509? What's the letters? The letters.
That
See.
amount is actually the total amount that was to be paid.
Okay, well, you said that that's what you pay on your,
Oh. I apologize. I misheard you. That is the total amount that was due on that judgment.
Gotcha. And how much are you paying on that judgment?
The last payment made was $1,200.
Okay, there was a garnishment in
Yes,
March?
yes, and
Okay.
that's the $1,200 payment.
Okay, and you're seeking some documents or information regarding her finances at this time? Is that what you're seeking?
Yes, ma'am.
What specifically are you looking to see?
I have a whole list of questions for the exam.
Let me see your questions.
Oh, I'm sorry, excuse me. Yes, sit down, please.
You may. Okay. You can put them in a private meeting room. We're gonna get you in a private space. Do you have a device with you that you can get on Zoom?
I have a telephone if that'll,
It's a
I tried
smartphone?
earlier and I could not make it work.
Okay, we can get you on Zoom on our device.
Okay,
And then you'll meet with her privately and you can get answers to that questions and I'll address the motion after the fact if necessary, okay? If you all come to a payment arrangement agreement, you can do that as well. If not, I'll make a determination on her request after this examination, okay?
yes, Your Honor.
Let me swear her in. Ms. Garvey, can you raise your right hand? Do you swear to tell the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. I'm gonna have you placed in a private meeting room with the plaintiff. She has a series of questions that she's gonna ask you as part of this debtor's examination so that she can figure out how she can get her money that she's owed, okay?
Okay.
All right. You can follow. Let's see. Okay. You have received a request to join the breakout room. And on the record, in the matter of Kurt Tipsy versus George Runciman, file number 23-00109 GC, council appearance.
Kimberly Dudley for the plaintiff, Your Honor.
Okay, Mr. Runciman is present here in the courtroom. Okay, today is the date and the time that's set for a motion. Let's see, because there's a lot going on in here. There was a motion filed on June 23rd, Mr. Runciman. You filed that motion, correct?
Correct.
You're requesting a motion to extend time to file and hear motions of counterclaim subpoena discovery currently expired June 15th. I have been working without any legal counsel, so was unable to file such documents in the correct form by the deadline. The trial date is August 23rd, or a trial date of August 23rd can remain, is what you stated. Then on June 30th, it looks like you filed a notice of hearing. You were requesting a transfer of jurisdiction from district court to circuit court as counterclaim or cross-claim seeks an amount or nature beyond the jurisdiction of the district court. But you had not filed a counterclaim or cross-claim at the time that you filed that. Is that correct?
That's correct. That's working
Your
on.
motion is denied as it relates to transferring of jurisdiction. You have to actually file and serve them with a counterclaim before you can make a motion for such. And you've not done that. In addition to that, their action against you does not exceed the amount. If your counterclaim or your action exceeds the amount, maybe you should consider filing that in circuit court, but you've not properly filed a counterclaim.
Yeah, I did that today and I got a court date the 23rd. You haven't got that. You would.
You're talking about this
late.
paper that was just brought up to me. Mr. Runciman,
Yes.
I think we've carried on way too long dealing with the back and forth. You were given back in March an extension so that you could file an answer. And at that time, you can file your counterclaim if that's what you wish to do. It is now July. You have not neither filed a proper or appropriately filed answer where you plead facts with specificity so that people can know what you're even suing them for, nor have you served that on the other party. It's July. We're going to trial in August.
Yeah. Well, the reason why it was, I didn't have an attorney, took me a month and a half to get an attorney, and I was turned down for attorney. That's what the delay was.
Okay, I recognize that I recognize you're gonna struggle with trying to get an attorney on this because there's no court-appointed counsel in a civil matter. You've requested that multiple times. This here, where you're requesting a notice of hearing a motion, it says the counterclaim against plaintiff for failure to execute writ of restitution. You say Act of 236 of 1961, 600.57441A, and I think that says B. And are you talking about Michigan compiled law? Because you just say 600.5744. What are you quoting, sir?
Yeah, I talked with somebody else, the attorney, so that's.
As required by Michigan Court Rule 3.106B1. What is Michigan Court Rule 3.106? What is that, sir?
That's what I was told.
So you don't even know what, you're just
Well,
writing
it
things
was the
down.
attorney that I talked to, yeah.
Do you know what you're writing? Do you know what these things are, sir?
Well, I figured that the attorney was correct.
No, I didn't ask you what the attorney knows. Do you know what these things are that you're writing in a court document and filing to tie up the court document? Because at this point, you filed 3 motions back to back requesting 3 separate hearings. Do you know what Act 236 of 1961 is?
No, I do not.
You do not. Do you know what Michigan Compile Law 600.57441A is?
No,
Do you know what Michigan Compile Law 600.57442 is?
no.
Do you know what the Michigan Court Rule 3.106B1 provides? Okay, but you're filing a motion in order for relief under those things.
Right.
Okay, your motion is denied because it's improperly filed and pled. This is not a counterclaim either, sir. I don't, you wrote counterclaim on here, but this is not a counterclaim. You asking for a writ of restitution must be executed within 56 days of issuance under Michigan Court Rule 4.201 and 4.202. This counterclaim will exceed the district court's jurisdiction. I find that your request here is not properly pled nor timely filed, but more importantly, it's not properly pled, so it's going to be denied. Your request to transfer the jurisdiction of the district court will also be denied because you've not properly filed a counterclaim. At this point, I don't even know if you filed your answer. And then your request to extend the time, which you filed that almost a month ago now, so that you could file a counterclaim and do subpoena and discovery. You still haven't filed an answer and a counterclaim, so I can't grant that either. What you're doing is tying up the docket. And I recognize that you may believe that you have a claim, but unless you can follow the court rules appropriately and or find yourself some competent legal counsel to represent you on this claim that you believe you have, I can't continue to let you tie up the other people's time. This is also a situation where you've missed court at least 3 times, and the other party has sent an attorney each time to defend them. It's costing them a lot of money because what you're trying to do and you're not able to do. Do you understand that? That's not fair to them.
Okay, well, I'm still trying to get attorney. Yeah, yesterday I did talk to one. That's where I was following what he was saying.
Okay, well,
Trying to.
Unfortunately, it doesn't even sound like you have a grasp of what he was saying because this language you put here, it really is gibberish. It means, that's why I asked you, do you know what you were asking for? Because this is gibberish. This doesn't give the court any clarity as to what you're seeking, and it sure enough wouldn't give a plaintiff's counsel clarity as to what you are seeking in a counterclaim. And so if you do later get counsel and they want to represent you on what you believe is a claim of action against the plaintiff, you can file that separately. But at this point, we're moving forward on the plaintiff's claim, okay? You have not filed a counterclaim, and I don't believe you filed an appropriate answer, but believe you essentially denied what they're requesting, and this matter has been set for a trial date after August 5th. Ms. Dudley, did you have anything to add?
No, thank you, Your Honor. I just got back from being out of state for the 4th of July and found these motions this morning, so I'm sorry I didn't have a response, but basically what you've said is what I was going to say, Your Honor, so I'm fine. Okay,
and then I'm sure you'll get the third one today because it was just filed today at 1:30, but I just addressed that one on the record.
Okay, Your Honor, appreciate it.
Okay, it looks like we just forwarded it to you, Ms. Dudley, so you should have received that one today as well. And so those motions will be denied. We'll continue to the next court action date under the originally filed complaint. Any additional matters for the record today, Mr. Russell?
Okay, that's the 23rd, right? July 28th or 25th?
I don't know, what's the next court date?
August.
They told me, we were downstairs, it was the 25th.
Who told you there was the 25th?
The secretary there, where I got a motion form. And it was
Of August.
hearing.
Big trial is August 23rd.
She told me 25th. Okay, I'll double check
Okay.
when I go down there. Okay.
Okay, yeah, we're scheduled for a bench trial August 23rd. Other than that, you're all set, okay, sir? Thank you.
Thank you, Your Honor.
Did you get disconnected?
Yes, ma'am.
Okay. Was there trouble in the private meeting? Was she answering your questions?
She didn't, some, but the majority no. She said she did not have to give me that information.
Okay.
I didn't
Ms.
say that
Garvey?
I didn't say that I didn't have to. I said I preferred not to.
Okay, well, you're under a court order to give this and provide this information, because it's part of a creditor's exam. I reviewed the questions and nothing that she's asking you, is information that you do not need to provide under this examination. Do you understand that?
Okay, but I don't want her having my current address.
Okay, well, then I'll let her proceed with a garnishment order, okay? I don't have another choice because you won't, the only other option is for her to find out how to get her money from you. If you won't work with her willingly to do that, then the other option is for me to grant a garnishment. Otherwise, she'll never get her money back, and you're proposing a payment plan that will all be dead before she gets her money.
Okay, but I'm the only one that is currently working. I don't even know exactly what all I can afford right now on my own. I've lost my brother, who was my other source of income, and I just moved into this place and I'm trying to establish myself there. So at the moment, right now, I only feel like that's what I can pay. I'm not saying that I don't want to pay at all, and I'm not saying that later on I couldn't pay more, but this is what I know that I can pay right this moment so that I can get something started while I establish what all my bills will be at the new place.
Okay. Can you get her question for me, please? I was trying to give you an opportunity to answer these in a private setting. If you want me to do it in a public setting, and I'll ask you on the record in a public setting, but you either give her the answers to her questions, which I've reviewed, and I find them to be appropriate privately, or we'll do it publicly. Okay, ma'am?
Fine, I'll do it privately.
Thank you. You can go back in the meeting.
I went to hit join and it disappeared.